Hello and welcome to Westchester Talk Radio. I'm Lisa Wexler. Today we're launching a brand new podcast called Senior Moments, brought to you by the Osborn Senior Living Community in Rye. I'll be moderating the show along with the Osborn's Vice President of Sales, Krista Daniello. Hi, Krista.
Nice to meet you.
Nice to meet you too. Krista, I know that you've worked in senior living for over 25 years. You have experience working with seniors that goes far beyond your role at the Osborn. Volunteer positions include having served as president of the Leading Age New York Retirement Housing Cabinet. Krista also serves on the board of directors of the Hudson Valley chapter of the Alzheimer's Association. She's well-versed in topics and issues of interest to seniors in the community. Thank you, Krista, for creating this information sharing forum and bringing it to Westchester Talk Radio. So for our first episode, who is the first person you're interviewing today, and what is the first topic?
Well, thank you. I want to say, first of all, Lisa, make me feel so important by that introduction. I thank you for that. It's wonderful to be here. And really, our goal is to give seniors information so that they have the ability to make informed decisions. My first guest for our inaugural podcast today, I'm lucky enough to have Michael Lamagna, who is actually an attorney. And not only is he an attorney, but if I tell you everything that he specializes in, it may take the entire show itself. But he's a client advocate. He concentrates in the areas of advanced asset protection, healthcare regulation, elder law, trust estates, probate, estate litigation, guardianship, and special needs and disabilities. One of the misconceptions I've heard is estate planning is very expensive and it's only for the wealthy. So I'm hoping you might be able to respond to that.
Sure. I actually say that estate planning is for the smart. It's for people that are smart, that really have the forethought to think about, okay, what's going to happen today, what's going to happen tomorrow, and what's going to happen when I pass away. You know, all too often people are very fixated on my will, what's going to happen when I die. But estate planning isn't just about what happens when you pass away. It's about what happens during your lifetime and whether or not you need decision makers to make decisions for you, and what's going to happen then if I need long-term care services, and then what happens after I pass away. You know, it's so important that you make the decisions for yourself. And then we have the whole estate planning where you're trying to avoid estate taxation, et cetera. But I'm so concerned about what's going to happen to you while you're alive and potentially losing capacity. And that's where we always start.
Right. I mean, you know, it's funny because, you know, some people will say, I've heard people say it's either too early or it's too late for me. And I think what I'm hearing from you is it's neither nor. It's not too early to start, and it's never too late to start for that planning. I mean, so you must have people all ages who are coming in and doing estate planning. Is that correct?
Well, we have college students who are 18 years old, who are going to school and, concerned, their parents, and they're concerned about, okay, if something happens, will I have access to healthcare information? That's technically estate planning because it's an advanced directive. And then we have people, I got a call yesterday from a 98-year-old who's worried about what happens if my funds run out and I need a trust. Will I make the 5-year look back period? And, I don't know how old you're going to be, but I do know if you are around in 5 years, it was probably smart to do the trust even at 98. So, it runs the gamut, and everybody's estate planning is very different and unique to them. My values have nothing to do with your values, and what your thoughts are about, leaving things to your children and at what ages, or what would I want to have happen if, I have an incurable, I'm in an incurable situation, where I have no discernible brain function anymore. My living will is not going to look like yours. So the decisions and spending the time with the clients to understand what their values are is extremely important. And that is at any age.
Another question that people ask often is, okay, if I die without a will my family decide where my money or my assets go? I mean, how does that work?
And people assume just because I'm married or, just because, these are my parents, that everything, when I pass away, everything's just going to be shared. And that's just not true. If you die without a will, which is called intestacy, and it does vary by state, the amounts. But essentially, what could happen and what does happen is you, the person who passed away, the decedent, you didn't have the ability to tell the courts what you would have wanted. So what happens is the courts have already made that decision by law. And what could happen is your assets could be split, let's say a house. If you own a house solely and you're married, or you own it tenants in common, what can happen is all of a sudden your house can be bifurcated, and your spouse gets part of the house and your children can get part of the house, or your assets can be divided amongst people that you had no intention of getting anything. Your documents, your estate planning is a reflection of you. You're telling the world and you're telling the courts, while I had capacity, this is what I wanted. So if you leave it up to the courts, they're not going to be able to tell. So what they do is they have laws. And very often, those laws may not be in congruence with what you want. So these documents are all just expressions of you, your values, and what you want during your lifetime when you pass away. So no, just because they're your children, your wife, your cousins, that doesn't necessarily mean that your family has any say in what's going to happen after you pass away with your assets.
One of the questions that somebody had asked me, or that I see often, is there's a remarriage or there's not a marriage and people live together. And I think there's a difference between common law states and non-common law states. And do you have to plan for that as well?
Yeah, it's very important. On both sides, it's interesting that I get clients that come in who have people that, that they're not married to, but that they want to leave assets to. And then, people that are married, that are second, third, fourth marriages, that want to make sure that their children are taken care of. So very often we look at trusts, and people get so confused with trusts, but basically trusts are just containers, just literally a container. And you put assets in a trust, and then you get to say what happens to them when you pass away in the container. So, very often, with remarriages or partners, et cetera, we'll make sure that one person, that the person that you have every intent of getting your assets, gets those assets. And also there's ways that they can hold the assets, they can have use of the assets during their lifetime. And then when they pass away, then it would go to your children. So there's a way to preserve assets for second, third, and fourth families. And it's very common, but you can't just leave it up to chance. And the other danger is that all too often, attorneys or lay people will just transfer assets from one partner to the other. When you think about it, though, from one spouse to the other, if you do that and then you pass away, it's going to all be in that spouse's name, and it's going to go to whomever they dictate. So it's really important that you consider all of these things, and that's why you have to get to know your clients and their family structures and what they're looking to do. Because, like I said, for Medicaid planning, you can transfer things to a spouse, and that's very helpful. But then you have to think about what happens when that spouse passes away. So there's multi-level thinking with all this.
Right.
May I just say, Michael, I know that you're admitted in New York and Connecticut. I think it's really important that people recognize that if they're going to seek legal help, that they seek a lawyer who is admitted in the state where they live, because even though we are neighbors, New York and Connecticut actually have very different laws with respect to Medicaid planning and some elder planning.
100%. There's, an Atlantic Ocean between the two. And, and that's why, it is very important that you go to an attorney who not only specializes, but that is admitted and understands the laws in the state that you're looking to get legal advice in.
I'm glad that you actually mentioned that. So, that just brings up a question in my head then. So what if, are you living in New York, but you have assets in another state? Does it really matter? How does that work? I didn't even think about that until you just said that, Lisa. So, what happens then? Do you have to have somebody specializing in different places?
The answer is you may need to. You can have a trust. I got a call yesterday from someone who has a trust in California, asking me about, what's going to happen when the dad passes away in New York. And there's assets here and assets there. So very often we do co-counsel with people that are in other states. And, I'm a big believer, look, I know what I know, and I don't know what I don't know. It's very similar to, I don't do any real estate. And, I'm not going to start practicing or give any advice on real estate. Well, same thing with, I'm not going to give any advice on another state's law that I'm not admitted to and not 100% familiar with. So But I will say that utilizing trusts are important with out-of-state property, because what happens is you have to probate your will, or if you don't have a will, it's called administration in every state in which you have real property in. So if you own a vacation home in South Carolina and you pass away and your house is owned in your name and not in a trust, very often you have to actually probate your will, which is the process by which your will gets validated by the court in New York or Connecticut, and then in South Carolina to get those assets within the estate. So the answer to your question, Krista, is very often we do utilize out-of-state counsel for especially real property.
You spoke earlier about advance directives, and one of the things that people don't understand are the different advance directives. So maybe that's something you could shed a little light on.
Sure. It's actually really, really important that people understand that having a power of attorney, a healthcare proxy, a living will are vital. And everybody needs one, regardless of your age. Especially being, I'll call it mid-pandemic. There were plenty of clients who, didn't have these documents that wound up sick in the hospital. Their assets were frozen, or they didn't have access to them. They didn't have decision makers regarding their finances and their health care. And we were doing things like, trying to get documents signed by Zoom, or, going to the hospital in, basically, astronaut suits and trying to get these things done. The power of attorney is the most important estate planning document, for finances. And what happens is you can appoint somebody either now or later on called a springing power of attorney to help you make your financial decisions. And so what that does is it gives you somebody, and it doesn't necessarily replace you. It adds somebody that can assist you. Same thing with the healthcare proxy. The healthcare proxy gives a healthcare decision maker only when you cannot make healthcare decisions. So, people are often, my God, are they going to pull the plug on me? That's not what it is. It's just you're the person that makes the decision when I cannot. And your living will tells your healthcare agent what you want when you're in an irreversible, incurable situation. So basically at end of life with no discernible brain function. You've made all these decisions already. Then therefore, these are the people that carry out your wishes while you're alive. And in the absence of having these documents, power of attorney, healthcare proxy, and living will, if decisions need to be made and you cannot make them, the courts then make the decision. And I'll tell you what happened. I never thought would happen, which is during the pandemic, most of the courts closed. And I actually was a guardian to several people in New York, and I had end-of-life decisions to make. And we don't have that authority here in New York as a guardian. And I was told, well, the courts are closing, and, just make your best judgment.
Wow.
That wasn't acceptable.
Oh my goodness.
Yeah.
That's
I never anticipated being, the courts not being opened. And the other thing is, it just was not a great time. However, the people that did the estate planning, my clients that had power of attorney, healthcare proxy, and living will, it was a different experience for those people, because then we were able to, if they were springing to enact them, we were able to get things done for people. I had plenty of clients who moved out of facilities and put into 24-hour, put into a hotel and get 24-hour care at a hotel if there was, rampant COVID, where they were in group homes, et cetera. So, having the ability to act when you need to act in an emergency is vital, whether you're in a pandemic or not.
If there's one thing that people should walk away with today, it's plan for the unexpected. So one of the things that people always ask me is, well, I have Medicare, I'm okay. I don't have to worry about home care or a nursing home. And I know for myself that that's not the case, but maybe you can talk a little bit about that and what nursing home costs really are, because I think people make a lot of assumptions about this and are very surprised by the time they get to needing a nursing home.
Well, so I've been in the industry. I'm a nursing home administrator for over 20 years, and I've run several nursing homes and, hospices, et cetera. So I'm very much in the industry as well. And, the biggest misconception or the biggest myth probably is Medicare will take care of me and my long-term care needs. And that's just not true. Medicare is a federal system. So it's the same in every state, unlike Medicaid, which is administered differently in every state. The Medicare will basically pay for very limited long-term care costs. So, for instance, if you're leaving a hospital or you're leaving rehab, they'll give you about 6 weeks Medicare of physical therapy, occupational therapy, speech therapy, maybe 4 hours a couple of times a week of home care. That's it per spell of illness. Then in a nursing home, Medicare will pay up to 100 days. Another big myth. So they could pay 1 day and they could pay 100 days. It's based on your needs and your rehabilitation needs. So they only have to give you 48 hours notice Medicare, whether you're on day 1 or day 90, that they can turn off the Medicare payments, and then you're fully responsible for the nursing home.
Well, Michael, you have been so informative. I just want to ask one last question, which, this is completely up to you. What misconceptions or what things would you want somebody listening to this podcast to walk away knowing the most as far as your area of expertise? Like, what should they walk away saying, wow, I'm glad that I know that?
It's the advanced directives. I can't stress them enough. And it's the first thing, we take our time to get to know the clients and make sure the documents reflect them. But we do the power of attorney, healthcare proxy, and living will first. Because you know what? Capacity is fleeting. The ability to do these documents, people can have them on a Monday and lose it on a Thursday if there's an accident or some sort of situation, or they're going in for surgery or have a stroke, et cetera. And they're so important that, the ability to get these done is vital. And everything else can stem from that. But if there's one thing that I'd want people to know is, these are not expensive. They're not time consuming. Nobody's ever died from doing their power of attorney and healthcare proxy and living will. It's never happened. It doesn't mean that you're sick or old. Like I said, there's 18-year-olds that do it. Talk to the people that you're going to potentially give these jobs to and explaining it to them and making them not scared to take over and making them knowing that A, you've chosen them, and B, you've made these decisions ahead of time. It brings down the temperature in a lot of families. It makes people more comfortable. And overall, it really lends itself to a much more stable life and having things done, the way that it should be.
Right.
Well, I want to thank both of you very much for joining us for this first episode of the Senior Moments podcast, which is sponsored by the Osborn Senior Living Community in Rye. Thank you, Krista Daniello, our host, Vice President of Sales at the Osborn. You're obviously so knowledgeable and so caring about this issue. And Michael Amania, local attorney specializing in elder care, who is admitted both in Connecticut and New York. Thank you both.
Thank you very much.
Thank you so much.
We'll see you the next time.